Good morning or good afternoon, wherever you are around Australia. This is Peter Towers from ESS BIZTOOLS. Welcome to this webinar on the services that ESS BIZTOOLS can provide to you, with a particular emphasis today on the Personal Property Securities Register. I hope you're having a good day and you've started the new year well. Well, this is a real challenge, isn't it, this Personal Property Securities Register. It's crept up on us a bit. It's been in a transitional stage for nearly 2 years, and on the 31st of January it becomes fully operational. And there seems to be a situation with many small medium enterprises around Australia that they don't know much about this legislation. So what I'm going to do today is, in this webinar, is give you an overview of the material that ESS BIZTOOLS has produced on the Personal Property Securities Register, and then we'll give you a quick overview of the products that ESS BIZTOOLS have available. If you have any questions, can you please type them in, and in webinar jargon, raise your hand, and I will try and answer the questions towards the end of the webinar. So once again, welcome, and I hope that we can answer some of your questions about how this legislation will operate. So the Personal Property Securities Register is a public register, and what it is securities over personal property. And I personally believe one of the confusing issues with this new legislation is this terminology, personal property, because it covers a lot more things than what most people would consider that the definition personal property would cover. And it's going to be available for everyone to access 24/7 for a small fee. So what is personal property? It's defined as all property other than real estate. So it covers a wide range of transactions relative to a business, including things like consignment sales, sale of anything with a serial number, motor vehicles, boats, aircraft. You can still have retention of title or the remalpa clauses attached to invoices, but if the remalpa clause hasn't been redrafted by a commercial solicitor in the last 2 years, it probably doesn't meet the requirements of this legislation. Goods stored on someone else's premises. Now, this legislation was first introduced into New Zealand in 2002, and Canada also, and it would appear that the Australian legislation has followed the New Zealand legislation very closely. And since 2002 there have been a number of significant court cases in New Zealand, and in the last 2 years, whilst we've been in the transition stage in Australia, there's also been a few court cases, and most of them have been centred on this situation where goods are stored on someone else's property, and the person who paid for them, the organisation or the individual who most of us would say was the owner of those goods or property, has ended up losing out to a liquidator or a receiver. So it's a very serious situation that's confronting many small, medium enterprise business operators. Goods attached to other goods can be part of this process. That means a new gearbox installed into a motor vehicle can in fact be protected under this legislation if you haven't been paid for it. Equipment renters, obviously they've in the main always got goods on someone else's premises. But it covers other things like receivables, debtors, if you've done a factoring arrangement. Livestock on adjustment, obviously the very word adjustment says that they're on someone else's property. Share farmers, security over a crop. they're growing a crop on someone else's property. One of the other key areas that's caused some publicity in Australia has been the situation with contractors having plant, equipment, machinery on a construction site. And what happens if the principal gets into financial difficulties and has a liquidator or a receiver appointed? There's been a fair amount of media coverage on this type of situation in a few incidents around Australia, and that's been during this transition period. Supplies of feed for livestock. Obviously this is products being supplied to someone and going to someone else's premises. Loans. Remember, the definition is covering all property other than real estate. So loans are an important consideration. There's been some comments that tenants' plant equipment stock on landlord's premises, if the landlord goes into liquidation, especially if the tenant didn't have a lease at that time, a lease agreement, could be at some risk. It's an area that perhaps you should be talking to clients and their legal advisors about. Intellectual property. Obviously it's been licensed from one organisation to another, and this licensing might be fairly close. It might be virtually an in-house licensing. But what happens if the organisations that is utilising that intellectual property gets into financial difficulties? Service entities, plant and equipment. A lot of professional firms, as you well know, have service entity arrangements. Is the owner of the property adequately protected? So what we have on the screen now we've split this chart into two because it was just too big to be viewed as one. So what we're looking at is what sort of transactions might fall under this legislation. So do any of those transactions that we just talked about apply to your client? And there's more than what we just talked about, but they were just some of the items I've highlighted for a webinar presentation. If yes, the Personal Property Securities Act probably applies to you. The real question is, have your clients sought legal advice as to how they're going to do it? And then there is a decision that has to be or should be made. Is the business going to register their security interest? Obviously they don't have to register every transaction, but I think the key thing is that the business should be giving proper consideration to this. And a little later in this webinar we're going to talk about some of these court cases, so you can see the type of issues that have been confronted by the courts. And the courts are basically saying that this legislation exists. Therefore, if you don't register, then you are leaving yourself at the mercy of the courts to decide what the outcome will be as to who owns the property. There is a need to obtain a signature from the debtor prior to lodging a document on the register. You can access the website at any time to check on a registration, and you might want to access the website to check on a particular motor vehicle that you might be going to purchase. So the legislation applies to all forms of tangible and intangible property, and any party with an interest to a transaction can potentially register their security interest on the register. Now this is a significant change. Some commentators are saying that this is the most significant commercial change that's occurred in Australia in the last 200 years. Some other people are saying this is bigger than the GST in its impact on business. And the real problem is that the government of the day spent a considerable amount of taxpayers' money in promoting and educating what the GST was all about. But unfortunately, there appears to have been little expenditure by the previous Labor government or the current Liberal government to explain to business operators how this legislation operates. There seems to have been a rush to issue some letters and email over the Christmas New Year period to businesses that the government agency running the register believes could have some interest in how this register operates. But in lots of cases it's too little too late. And as I see it, the key group that can try to encourage small, medium enterprises to have a look at their situation to see whether they need to do something on this legislation are you people, accountants. There's no doubt that many of your clients should be going off and consulting their solicitors, but they probably have far more contact with you than what they do with the solicitor. So the key thing here is that there is a benefit, and the benefit is you're able to claim ownership of your property, the property that your client has paid for, but it's subject to a very important provision. They must register their security interest on the public property securities register. If they don't register their interest, they are in a very weak position. They have no priority if someone else lodges a priority claim, a security interest. Now, admittedly, in most cases, this is only going to come to a head if the debtor or the organisation that owns the property on which the plant and equipment or whatever it is, a horse, as we'll look at when we look at some of the court cases out in New Zealand, are situated, and a liquidator, receiver or trustee in bankruptcy is appointed. I mentioned before the remalpa clause is not enough protection because you need to have a signed terms of trade, and then a financing statement has to be registered on the register if you are to be protected against third-party claim. So up until 2 years ago, businesses were relying on remalpa clauses on their tax invoices to be able to repossess, in effect, any goods that were able to be seized that hadn't been paid for. Your clients won't be able to do that in most cases when a liquidator or receiver has been appointed, because they will, in all probability, have already gone round, looked at all the items that the business owns and have registered their interest on the register. And your client will find that they haven't got a priority. So if you are using a remalpa clause on your invoices, or your clients have, and the customer has signed the terms of trade and the financing statement has been registered with the register, I've worded there in most cases because it's always difficult to say in all cases, but it would appear that in virtually every case a liquidator will not be able to have a claim against those goods or services. But goods or products. But if you haven't, or your client hasn't lodged that paperwork, when you have no protection against the register. There's a preferential payment situation. A liquidator will have a claim if a creditor's debt was unsecured, so there's been no financing statement lodged on the register, and the company has been making payments to the creditor within 6 months of what's called the relation back day, which is basically the day the debtor become insolvent. Now, I understand there's a situation in one of the states at present where a business that constructs kitchens has been constructing kitchens and supplying them to builders who have been using them in display homes, and the trades organisation hasn't been paid. They've been receiving a rental or lease payment for the use of the kitchens. The builder has got into financial difficulties and a liquidator has been appointed. The liquidator has put in a demand for repayment of the lease payments that have been made for the last 6 months. And obviously, you've probably already gathered, the trade organisation that built the kitchens apparently has not lodged any registrations with the Personal Property Securities Register. And it's claimed that the liquidator has in fact registered that those kitchens on the register. So that particular trades organisation looks like not only losing their kitchens, but also the payments that they've received for the lease of that property over the last 6 months. That's just to repeat there what we said about security interest. It has to be in writing, it has to be signed by the grantor. Now, the legislation has had a transitional security interest period which has been running for nearly 2 years, and this expires at the end of January this year. And this was enabling people who had situations already occurring at the 30th of January 2012 to take action to gain some priority under this legislation. So they were able to create security interests. And obviously, if you had clients who had that situation and they have done nothing about it in the last 2 years, there's 8 days remaining until the 31st of January that they might wish to do something about it to protect their interest. Because the transitional period expires at midnight in Canberra on the 31st of January. Now, one of the issues that can be looked at in this situation is to do with loans. If you have a client that's got a situation where loans had been made at the 31st of January 2012 and those loans still exist, then a security interest could be lodged before the 31st of January. And the benefit of that is that your client would then get an immediate priority if anything happened to the borrower. Whereas otherwise, if they lodge that security interest after the 31st of January, they will then have to wait 6 months before they were able to gain a priority if something happened to that borrower. So if it happened in the meantime, they wouldn't be able to get a priority. So that's the real benefit of the transitional security interest that you might want to consider if you've got clients who have loans. So an unregistered security interest, no one's forced to register a security interest on this register. But what you need to be, I think, encouraging your clients to think about is what would be the consequences if a major debtor did not pay them, or property that they own or they've paid for that is situated on someone else's property was in fact seized by a liquidator or a receiver. What effect would that have on their business? So in most cases it comes back to the amount of money involved. If it's only $1,000, perhaps people won't worry about it. But if it's $100,000, or in some businesses, $20,000 could be a major concern. So your clients, I believe, are going to need advice as to what their strategy should be in registering these security interests. Now, we started talking about loans before, which was to look at the transitional period. But with loans, you need to document the loans. You just can't go off and register a loan on the register unless it's a documented loan that's been signed by the borrower. And some other commentators on this whole legislation are emphasising the desirability of businesses fully documenting their loans to associated and very close businesses, because there's nothing to say one of those other entities will not get into some sort of financial difficulties, and it will be very difficult to protect that position. Intellectual property is another one where it is an asset that could well be being used by another business. Has it been appropriately documented, and does the business want to secure their interest by registering it on the register? Tenants, landlords, I referred to that in the introduction. This is where there's plant, equipment, stock in retail or any sort of premises. If something goes wrong with the landlord, is there a potential risk? My suggestion is that if your client's in that position, you should be encouraging them to talk to their solicitor. So this brings us really to the pre-sale activities and the sort of things they probably should be talking to their solicitor about. It's pretty important that businesses make sure their terms of trade are up to date. So that's the retention of title clause, the RMAPA clause, and any other clauses they have in the agreement, making sure they've received legal advice that these clauses comply with the requirements of the legislation. It's important that they make sure that these terms are signed by their customer. They can then proceed to register the financing statement. Now, if they want to get their best possible security, which is called a Purchaser's Money Security Interest, a PMSI, they need to complete those steps before they supply the goods. Now, in the actual world of business, this might not be possible. But if they want to get their best possible position, they can gain what is called a Purchase Money Security Interest, which is an absolute priority over anyone else's claim. Because you can have more than one organisation claiming a priority over various assets in the event of a liquidation, receivership, etc. We think it's imperative that small businesses should be receiving legal advice. From my own experience in advising a wide range of small, medium enterprises over the years, I know that many of them really do not have a regular contact with a solicitor. If you ask them who their solicitor is, they're likely to talk about someone that helped them in a car accident 10 years ago or handled their divorce 15 years ago. My advice to you is to urge them to be seeing a commercial solicitor so that they can get proper input on what they are doing on their documentation to make sure that they comply with the requirements of this legislation. And then they need to inform their customers that these are the requirements, and obviously they need to make sure that staff have been trained and they've introduced a system to make sure that a proper consideration is given for each transaction, perhaps above a certain amount of money, and perhaps taking into account what the item of plant, equipment, etc. is that might be going to be placed on someone else's property is. But it needs to be thought about to see whether they need to proceed to lodge the security interest on the register. Now, I mentioned court cases because the court cases are very interesting, and obviously will give you a fair idea as to how this legislation's been interpreted by the courts. We've summarised, in effect, 5 cases here. There's been the first 2 are New Zealand cases because their legislation started in 2002. There's been a number of court cases over there. The first one involved leased portable buildings which were placed onto a construction site. The person who paid for them, the person I would call the owner, did not register them under the PPSR in New Zealand. The business got into difficulties. The mortgagor appointed a liquidator. The liquidator apparently went to the property and listed every item that he located on that property, and then went to the register, and if that item was not already registered by someone else, he then registered everything that he could. And that obviously included these leased portable buildings. This ended up in front of a court in New Zealand who decided that the liquidator was in his rights doing that on behalf of the mortgagor, and the owner, the person who had paid for those portable buildings, lost out. Another case involves a farming business who had the use of a stallion for breeding purposes. The farming business got into financial difficulties. A liquidator was appointed, and the court supported the concept that the liquidator was able to sell the stallion, which I understand was sold for $2 million, to recover funds for the secured creditor. Obviously, even though the stallion was not owned by the farming business, hadn't been paid by them, but the owner had not registered their interest on the register. In Australia, I've listed 3 cases. Wow Sight and Sound in Queensland, a number of their stores got into financial difficulties, and a liquidator or receiver was appointed. The liquidator obviously did a stock take and went to the register to register any of the property that was not already registered to someone else. He found there was a wide range of stock that had been supplied, some on consignment, some hadn't been paid for. He registered that. Marketplace rumours say that the total of that stock was $27 million, and the owners of that stock were not paid. The liquidator was able to use that to satisfy the requirements of the secured creditor. QES was a situation where construction equipment, Caterpillar equipment, was placed on another business's property. That business went into liquidation. Same situation. The liquidator checked the register. This particular Caterpillar equipment had not been placed on the register, had not been registered. He was able to claim that as a priority and utilise the value of that sale of that plant and equipment to gather funds for the secured creditor. This all sounds very tough to me, but I can assure you these are the cases, and we need to be, as accountants, considering them for our clients. Kentor Minerals was a case in Western Australia where a contractor supplied a water tank worth $300,000. Kentor Minerals went into liquidation. The water tank had not been registered on the register, and the liquidator was able to seize that asset and sell it. So, real food for thought there as to what is happening. it seems to me that the courts are saying that the legislation's been introduced by the Parliament. The Parliament has made the provision that businesses, to gain absolute protection, need to register on the register, and if they don't, they receive no benefit, no protection under the legislation, and the courts are not going to give them that protection. So my recommendations on what needs to be done on personal property securities register is that you talk to your clients and suggest that they see a commercial solicitor to review their retention of title clauses, to review their terms of trade, and that they then have a discussion with you to establish an appropriate workable system that will work in their business to ensure that these types of situations that I've alluded to in those 5 court cases don't occur for them, and that they have procedures which involves a fairly close check on every sale, especially where it's a sale that would have activated a remalpa clause on the system up to 2 years ago, or involves placing of something in someone else's possession, whether it's portable buildings, Caterpillar tractors, formwork for a building, tradesmen's equipment, etc. What's their system to make sure that they're going to be able to get paid? So the system also requires the customer to sign the terms and then to go through the actual financing statement being registered on the register. There is a recommendation from an organisation that's been established because they believe the government was not doing enough to promote to small businesses how businesses should go about reacting to this legislation. And we're going to talk about them in a moment. It's an organisation called PPSR Protection. They are recommending that after you've talked to your client, that you send them a letter confirming to the client that you've had this discussion with them and you've made certain recommendations to them, possibly to go and see a solicitor, and that you get the client to acknowledge that they've received that letter by signing it and sending a copy back to you. PPSR Protection is concerned that there's going to be a fair bit of litigation start flowing out of this Personal Property Securities Act in 2014, and people are going to be claiming that they haven't been properly advised by their key advisor. So this other organisation that I'm referring to is PPSR Protection. It's run by Mr. Rick Nash. The web address is www.ppsrprotection.com.au. They operate in Sydney. They have a very interesting website. I'd suggest you have a look at it. It contains various bits and pieces of information about this legislation. They have entered into an arrangement with a firm of solicitors to prepare terms of trade and retention of title clauses and anything else that businesses need for a cost of $1,825 plus GST. So if you're interested in talking to them, there's their web address, and we will be sending you these PowerPoint slides at the conclusion of this webinar. So you'll be able to make contact with PPSR Protection if you want to get some of their material. So the sample letter is prepared so you can send it to your clients. So that's the material that I wanted to talk to you about on the Personal Property Securities Register. It is important, and I do recommend to you that you urge your clients to be seeking out advice. Now, I did get a message there, but I'm not quite sure to what it related. Gary, if you can just explain a bit further, please explain this clause. Unfortunately, I didn't see that when that came in, so I don't know what clause you're referring to. So if you want to just send me another message with the name of the clause that you're referring to, I'll try and answer your question. Whilst Gary's doing that, I've gone onto the website now of ESS BIZTOOLS. ESS BIZTOOLS is a product that we have prepared. We've been marketing to Australian and New Zealand accountants for the last 12 years, which supplies tools and articles and papers, newsletters, pre-prepared seminars, webinars to assist accountants to deliver a range of non-compliance services to their clients. So we have products that relate to business advisory services. Within that, there is material to assist an accountancy business to get ready to offer business advisory services. Then we have a product range. There's 14 separate products at this stage. There'll be 3 more added this year that guide you through the actual offering of services such as succession planning, chief financial officer services, cash flow management, buying a business, selling a business, etc. to clients. So to give you a leg up, as it were, some assistance to get started in delivering business advisory services, we have prepared a range of forms, templates, letters that will assist you to do that. Business Plus is a newsletter we produce each month, other than January, with articles that are targeted at your small, medium enterprise clients, articles which invite them to take some action by contacting you to get further advice and assistance in particular areas. There's not much taxation information in our newsletter. We concentrate on business issues, budgets, cash flows, business conditions, succession planning, human resources, workplace health and safety issues. You can add to the material if you wish, and most definitely you badge the newsletter with your name and send it to your client so that they perceive you've sent it to them. Client mentoring and coaching. We have 14 modules that you can utilize to educate your client on some of the additional services other than compliance that your accountancy business is able to supply to them. So you can progressively send that to selected clients. So the sort of modules include for someone buying a business, for someone starting a business, for someone selling a business, for someone that's wanting to know more about budgets and cash flow forecasts, for someone that wants some advice on how to handle their bank, for someone that's interested in raising money, capital from business angels, that type of thing. Leadership modules have been written by an independent consultant and includes 9 modules on various leadership strategies that you could introduce, first of all, into your own accountancy business, but then you could guide your clients through leadership strategies. The ESS papers, they're the backbone of what we have. There are 480 papers targeted at small, medium enterprises that you can select whichever one you want and place your name on them and send them to your clients as a way of promoting further understanding of what particular services you can supply are all about. And there are 50 odd papers that are targeted at accountants, summarising the range of activities that we talk about and how you might go about better presenting that type of material and services to your clients. We have client seminars. There are 35 pre-prepared seminars that are ready for you to present to your clients. Everything's prepared, ready for use. We also have ESS BizGrants. This is a separate product on a separate website which facilitates the identification of grants for small medium enterprises, that you can be seen to be very proactive in identifying the grants that might be suitable for that particular client. So we go through a process. It will take you 6 minutes to initially record the initial client profile, and then about another 6 to 10 minutes to review the results that are produced. You're then able to produce a report that has your name on it and the client's name on it, and contains a précis of what that particular grant's all about, that you're able to present to your client and have a conversation with them as to whether they wish to proceed with an application, whether they wish you to do that. And obviously this is a new fee for service arrangement, and what that can lead to is some very interesting work, because there's a number of these government grants, particularly Enterprise Connect, which is the largest individual grant in Australia, which is basically solely targeted at small medium enterprises. There's a fair amount of work that's paid for by Enterprise Connect that can be undertaken by accountants who are offering a business advisory services. Then we've got hundreds of client forms and tools within the system. So that's the overview of ESS BIZTOOLS, and I hope that will give you a brief overview of the products which we have. If you are interested in hearing more information about our products, please don't hesitate to contact us. A 12-month subscription which covers everything that I've just shown you, including our new product on the Personal Property Securities Register, which will give you a guide for how the register is going to operate for different types of businesses, is available to our clients. Our gold subscribers receive all of our material, and the subscription for that is $2,700 plus GST for 12 months. Now, I've got some clarification as to what the question was about. Retention of ownership clause. The retention of ownership is basically a clause that was being placed on invoices or within sales contracts by many businesses that were supplying goods or plant or equipment that could have been repossessed if payment hadn't been made. So it might have been office furniture, it might have been air conditioning plant, it might have been computers, it might have been coal stores, shop counters, cash registers, all that sort of equipment. And the clause that was drafted as a retention of title clause was generally known as a Ramalpa clause. It was named after an Italian gentleman, I understand, who must have been the first one to dreamt the idea up. Now, Ramalpa clauses were fairly effective for being able to claim to repossess goods that had been invoiced, delivered, and were not paid, if you could actually go back in and take the goods back out of the premises. Apparently, once a liquidator was appointed, though, that all become a little bit more difficult, and the government would claim that one of the benefits of the personal property securities legislation is that these matters have been clarified, and if a business has sold goods with a retention of title clause and has had the customer sign the contract and has been able to lodge their security interest prior to the delivery of those goods, then that business, that client, is able to claim what is called a purchase money security interest, the PMSI, which is the most senior protection that can be obtained under this legislation. And that's the whole reasoning behind the retention of ownership clause, to be able to be claiming ownership which will defeat the claim for a priority claim by any liquidator, receiver or trustee in bankruptcy. Unfortunately, if your clients do not have the protection of the PPSR, then they, in all likelihood, are going to face the same consequences that the businesses that were the owners and paid for the various items, the horse, the stallion, the portable buildings, the stock that was in WOW stores, the Caterpillar tractors and bulldozers, etc., that were on the property. Incidentally, it's claimed that that value was 1.2 million. And the water tank. So in all those situations, the real problem was that what I would call the legitimate owner had not proceeded to protect their interest. And I really don't want to see a significant number of these types of law cases emerging in Australia over the next few years. It's no good for business. It's a matter of being pre-warned, making sure your clients understand how this legislation works, and encouraging them to receive legal advice, make sure their documentation is correct, and then one of the other big issues that I really believe is in your court, that's a pun, isn't it, is in your area of advice that you can give the clients, is making sure an appropriate system is established and that they abide by it to protect their interests. Because in 6 months' time, someone just new might be completely unaware of what the system is, and a large item of plant is sent to someone's premises and forgotten about, and if subsequent to that a liquidator gets appointed or something like that happens, then your client could be in real financial difficulties. And as Mr. Rick Nash from PPS Protection says, this legislation has the potential to completely wreck businesses. The GST didn't have that effect. It was just another 10% charge, which sure systems had to get put in. And the real concern here is that the government of the day, the Liberal government, when the GST was introduced, spent millions of dollars running education programs, paying accountants, including my firm. We did some work on the GST education process to educate small, medium enterprises to how that legislation would work. Yet now we have the PPSR, and I have not seen any government agency offering any education, training or advice other than a spate of letters and emails that seemed to get pushed out during the Christmas New Year period. And that didn't offer any education. It just told people that this legislation become fully operative on the 31st of January 2014 in 8 days, and we have a 3-day weekend in between. So I know all you people are non-subscribers to ESS BIZTOOLS. This is the sort of material that we produce to keep our clients, which are hundreds of accountancy firms around Australia and some in New Zealand, aware of issues to do with small, medium enterprise operations. We supply you the material. It's available 24/7 on our website. You access it through a username and password. If you're interested in talking to us, we'd be happy to hear from you. We will send you a link to a YouTube recording of this webinar if you wish to hear it again and perhaps talk to some of your colleagues, and we will also send you an email with the PowerPoint slides that I've used today and a copy of the letter that Mr. Rick Nash from PPSR Protection is suggesting that you might send to your clients. There doesn't appear to be any further questions. Thank you for participating in this webinar today. If you think of any further questions, we're quite happy for you to send us an email and we will respond to you. Thank you very much and have a wonderful day. Thank you. Bye.